Record in the Simpson matter. All the parties are again present. Counsel, anything we need to take up before we invite the jurors to rejoin us?
Yes, Your Honor.
Ms. Clark.
Well, this is a motion presented by Mr. Bailey.
All right. What I propose we do is, why don't you take a look at it over the noon hour, and we'll take it up. I accept Mr. Bailey's representation off the record that he will not go into those areas today.
But that doesn't address the people's concern. If the court is inclined to rule in defense favor, which the people see no reason for the court to do, we have read the motion and the reasons that generated the motion, and we see no merit to the request. Nevertheless, if the court does intend to rule in the defendant's favor with respect to the parameters of cross-examination, the people are entitled to know about this one before we finish direct, because these were items that the people raised in the people's motion. The court issued a ruling, and based on that, we made a decision as to how we would proceed with direct. If the court is now going to change
Well,
that...
let me, excuse me for interrupting you. Do you want to litigate it now?
Yes.
Okay. I left it on my desk. Ms. Robertson? Thank you. All right, Mr. Bailey, do you wish to be heard?
Yes, Your Honor. You will recall...
No, if the defense wanted Detective Ferman present.
All right,
we ask him to
Detective
leave.
Ferman, could we ask you to step outside, please? Thank you. All right, record shows like that Detective Ferman has withdrawn from the courtroom. Mr. Bailey.
Your Honor, we have visited this subject on several occasions under the umbrella of the mandate of the Anthony case decided in this district. You had issued a ruling barring certain evidence of statements made to psychiatrists and reports of psychiatrists in connection with litigation instituted by Mr. Ferman in the early 80s claiming a disability because of certain experiences he had had. And at the time that you issued that ruling, it was represented to the court that Mr. Ferman would not be a witness to the 1985 incident involving the Mercedes-Benz windshield, and that he would not be involved in the 1989 incident, which in fact went to court. Now, the prosecution opened right up with that. In addition, and this is a first in my experience, they opened up without specifying that he had been subjected to some kind of special training session that had nothing to do with the murders at Bundy or the evidence at Rockingham. And it seems to me that the question of Mr. Ferman's global attitudes toward race specifically, and in particular couples that are racially mixed, such as Mr. Simpson and Nicole, is fair game for questioning, inasmuch as he is very definitively a suspect for having carried that glove from Bundy, where he found it, to Rockingham, where he deposited it. And that's what we intend to show by circumstantial evidence far stronger than the people will ever offer against O.J. Simpson on the murders. If motive and opportunity are the means that the people use to prove the guilt of the defendant, which they say they can do, that is a fair method to prove the innocence of the defendant by showing that he was framed. The opportunity will be patent if it is not already on the record by the time Mr. Ferman's cross-examination is complete. The motive, one that would incline a police officer to do something this drastic, even though he had no way of knowing, presumably, whether or not Simpson was in Timbuktu at the time that he was at Rockingham first, is certainly very highly relevant. If it is embarrassing, it is an embarrassment of his own creation. He is the one that created these psychiatric reports and caused them to be filed publicly, hoping to gain as a result. Insofar as the original concern that Your Honor had as to remoteness is concerned, I ask Your Honor to look at the rulings that were made with respect to spousal abuse and the time brackets that the prosecution was permitted to cover. Of special significance is the fact that Detective Ferman's own expert opined in the reports that you have reviewed that his anti-racial feelings were incurable and that there was no way that he could continue to be an effective police officer because of that. And if that condition is shown to exist, then it seems to me that the burden of going forward may shift to the witness to show when and if such a cure took place, because we intend to show in incident after incident that Detective Ferman was willing to violate the law and the federal civil rights statute to unfairly prosecute black men who he found in the company of white women, and that this pattern was consistent right up until shortly before this incident. Based on all of those facts, the starting point, and we're not seeking at this point to go back to his Marine Corps experiences, which are out there, but the starting point which relate to those, and why he wanted to get out of the Marine Corps, because he could not stand the defiance that minority groups were handing him when he gave them direction, and why he wanted to get out of the police force, because he couldn't take the conduct of the people he had to deal with, is part of a total personality picture that this jury is entitled to evaluate, because ultimately they're going to have to evaluate the question as to whether or not this officer, incensed at being kicked out of the biggest murder case in the history of this state, decided to keep himself in it by becoming an indispensable witness, as he surely has done. That is our presentation, and in that context, I think that we're entitled to have the court reconsider its earlier ruling that these psychiatric reports are verboten. Thank you.
Ms. Clark.
Yes, Your Honor, I don't really think the court needs to hear a lot from the people. The defense has really not offered you any reason to change the earlier ruling that you've issued. What they're basically arguing to the court is that the fact of the court's permission for the defense to use the Kathleen Bell allegations, which we will disprove, nevertheless, the fact that the court issued that ruling is now basically being posited to the court as an excuse to go back into the very items that the court ruled to be too remote and inadmissible. The fact that the people decided to air those incidents that the defense has been threatening to use against Detective Ferman by waiving the Newsweek article back in chambers about the mock cross-examination, by the discussions in the nightly press conferences concerning Kathleen Bell and her credibility and what they're going to prove via Kathleen Bell, the people determined as a tactical matter to basically do a preemptive strike and air those matters first on direct examination. But that doesn't open a door any further than it was already opened by the court's ruling. The court ruled that certain things would be admissible, ruled that the Kathleen Bell incident was admissible. If you were inclined to allow the 81 incident, you would have done so. But the mere fact that you've allowed the defense to go into the 85 incident and then the people air it on direct, knowing that the court is going to allow the defense to do so on cross-examination, doesn't open the door any further than it was to begin with. You issued a ruling, you said a certain incident was admissible, and that the defense could go into it on cross-examination. The people were aware of that ruling, but the people were also aware that the court ruled that the 81 information could not be aired. I don't see how there's any different posture now, simply because of the fact that we discussed it on direct examination. I see, and then the court is not given, notably, any relevant case authority to justify this position. It's simply counsel's bald assertion. When you consider the fact that the defense has never and will never be able to demonstrate either the opportunity or give any kind of real offer of proof to this court that Detective Ferman planted anything, it's really. And yet they got the 1985 incident as grist for their cross-examination mill. I really think it's already beyond the pale. They will never be able to give this court an offer of proof. They haven't to this date. When the people have requested that they do so, give us an offer of proof. Show us how you're going to prove that this detective planted this evidence. They have not once been able to do so. They have refused to do so. And the reason they've refused to do so is they cannot. There will never be any such evidence because it's an impossibility. And even though there was no opportunity, and it's a virtual impossibility for him to have done what they allege that Detective Ferman has done, yet they got the ruling from the court, which was very generous, allowing the 1985 incident for impeachment. To now argue that that very ruling, which the people acted upon, allows them to go further is ludicrous, is without authority and without logic.
Forgive me for interrupting you, Ms. Clark, but don't you think that a prior relationship or a prior meeting between the interested parties, Nicole Brown Simpson, the defendant, and a key prosecution witness, you say that's a generous ruling?
No, I'm not talking about that. I was talking about the Kathleen Bell
Well,
incident.
we're speaking of the 1985 incident.
Excuse me. I'm sorry. The fact that that Detective Ferman responded to the 85 incident is not it was not a significant event at the time. In fact, so insignificant that he did not generate a report. He simply responded to the location, was certainly not the only officer to do so. And we will hear from that other officer later on in the case who was also present at the scene. But that in and of itself was obviously not a great event, and it was not something that he even remembered until requested to report on a prior incident back in '89.
No, I was just concerned about your characterization of that as being a generous quote-unquote ruling. I thought I was pretty much compelled to allow the jury to hear that there was some prior contact amongst these parties.
That's true. I'm not arguing that. I was arguing the Kathleen
Okay.
Bell incident, just the Bell incident, Your Honor.
All right.
That was the only one.
Well, no, but Mr. Bailey makes the argument that since we have gone in at some length the 85 incident, then they're allowed to go into they should be allowed to go into the 81 issues.
And I understand,
Okay.
and I think the argument has absolutely no merit. There's no case authority to justify it, and there's no logic to justify it. They are in no different position now than they were when the court ruled earlier. The same information was deemed admissible then, as is now. The court made a ruling saying that the Kathleen Bell incident could come in. The defense was aware that we were going to be proving the 1985 incident, and the defense was very clear in its indication they were going to use the prior contact with Mr. Simpson to try and paint a certain picture of Detective Ferman and his activities in this case, which, as I understand it, is part of why, may have been part of why the court allowed the Kathleen Bell evidence in. So the court made its ruling based on the fact of the prior contact and then the content of the Kathleen Bell allegations. But the fact that the people elicited this information on direct puts the defense in no different posture. It doesn't make the 81 information any more relevant than the court earlier deemed it. What is the change in circumstance? The court made a ruling on what is admissible. The people acted upon the ruling. And so what is different? Based on their argument, Your Honor, if they brought out the 85 incident and they brought out Kathleen Bell, which obviously they were going to do, they would then be able to stand up and say to the court, well, now that we've brought all this out, we can bring out the 81 incident as well. What's the difference? Same thing. I don't see the change in circumstance. Perhaps if the court does, it could give an indication, but other than their bald assertion that they got this much and so therefore they get this much more, there's no logic and there is no case authority to support the request.
Well, just so we all understand, the basis for the court's ruling on the Kathleen Bell incident is stated in the court's written ruling. However, just so we're all operating from the same sheet of information, it's because of the allegation, one, of racial bias, and two, the willingness to fabricate information regarding interracial couples.
Right.
Which is very specific to the facts and circumstances and similarity to this case. So I felt compelled to allow that for cross-examination.
And the people accept the court's ruling, and we
Right.
understand.
Okay.
And all I'm saying is that by virtue of that ruling, the defense does not now get to go and say, well, now the door is open wide. No, the court has already indicated how far the door is open. And it doesn't get opened any further because by virtue of its own ruling, it's kind of a weird, illogical argument. And the people fail to see any merit in it whatsoever, and obviously there's no case authority to support it. People urge the court not to extend the parameters any further.
All right. Thank you, Ms. Clark. Mr. Bailey, any response?
Just this response, Your Honor. First, you will recall that Ms. Clark was at great pains to elicit from Detective Ferman all of the things he could have done to Mr. Simpson in 1985, as if he had the right to arrest him, pat him down, interrogate him, follow up on the case, to show a lack of animus. Now, that's grabbing the bull by the horns. The word preemptive strike in the trial of cases is spelled W-A-I-V-E-R, and that's true in this case. Furthermore, in the extraordinary set of circumstances where the prosecution felt compelled to acquaint the jury with the fact that this witness required special training so he could control himself on the witness stand, we're entitled to show why that special training was and always will be necessary in his case. And I think they have opened the door wide. You can't just change the rules based on a court's ruling, which reflects other bases, and then say, but we don't want to pay a penalty for that. They took the bit. And I think that the defense is entitled to walk through the cavernous door that they've opened.
All right. Thank you, counsel. Let me just ask Ms. Clark one follow-up question. It's your position that if the court were to grant this wider range of inquiry, you would want to reopen, correct?
Yes.
All right. Thank you. Only at the risk of opening the door for Ms. Clark to respond.
I realize that that's a substantial risk, but I left out something that I think is extremely significant, and that is the people displaying to the jury the Bell letter. They chose to do that. They chose to put those words in the jury box, and I think that that ought to be considered, at least by the court, in deciding whether or not there has been a change in circumstances. That's all.
All right. Thank you. Do you want to respond to that last point, Ms. Clark?
I can't see how that makes any difference at all. Unless the court thinks that it does, I will address the issue, but
No, this is just your opportunity to give me the benefit of your enlightenment.
I would be delighted to do so, but only if required to do so. I don't need to burden the court with more statements. I don't see any merit in the additional comments of Mr. Bailey. I think that it makes no difference. And if the court thinks it does, I will address that point. Does the court?
I object to the court previewing its ruling so Ms. Clark can decide whether or not an argument is necessary.
Oh, it's just a very clever way to address these matters. Ms. Clark, actually, the option is yours. If you want to address it, fine. If not, fine.
Other than just to tell the court it makes no difference. Catherine Bell was there to give testimony, whether it was with a letter or not.
All right. All right. Court's previous ruling will stand. Let's proceed. All right, David McNair, let's have the jurors, please. Let the record reflect we've been rejoined by all the members of our jury panel. Detective Mark Fuhrman is reapproaching the witness stand. Good morning again, Detective. You're reminded you were still under oath.
Yes, Your Honor.
Mr. Bailey, you may commence with your cross-examination.
Good morning, Detective Ferman.
Good morning, Mr. Bailey.
Could you tell us when it was you were enlightened as to the fact that the plastic you saw in Mr. Simpson's Bronco comes with the car, when you learned that?
Yes, I believe it was Saturday.
Saturday.
Yes.
So that after 9 months of investigation, you discovered on Saturday that this important piece of evidence was perfectly innocuous. Is that right?
Objection, license back on that one.
Sustained. It's argumentative.
Okay. Now, when you first saw the shovel in Mr. Simpson's Bronco, did you think that a significant find?
I don't think significant was the word I would use.
Do you have any experience in digging, Detective Ferman?
Yes, sir.
Do you know the difference between the kind of shovel used to dig a hole and the kind of shovel you might use as a scooper, for instance?
Yes, I do.
Okay. And what kind of shovel is this?
Well, that's the type of shovel you use to muck a barn.
Okay. Or scoop up doggy-doo, maybe?
It's a little large for that, but I think I see what you
It
mean.
would work, wouldn't it?
Yes, sir.
Okay. Now, as I understand it, your colleagues, Detectives Van Adder and Lang, on the 13th day of June, 1994, had a total of some 3 hours in the company of Mr. Simpson, correct? Did you learn that?
I've never heard the time, no.
You know they talked to him, don't you?
Yes, I understand.
You know
yes.
that the part of what they exchanged with Mr. Simpson was taped, don't you?
Objection, relevant beyond the scope of hearsay.
Overruled. The fact that they had a tape conversation is a fact. It's not the content.
Yeah. Part was taped, part was not. Was that your understanding?
Objection, Your Honor.
Sustained. That's assuming facts not in evidence.
Okay. Do you know if a formal statement was taken at some point on that day? Just yes or no?
Objection would be speculation on this. Please.
Overruled. You can answer the question.
I can only say that through other sources I assumed and I heard, but I had never seen anything or heard anything.
You never talked to Detectives Van Adder and Lang about what the suspect had said during 3 hours of conversation?
No, I didn't.
Never did.
Sustained. Curious to disregard that. Mr.
Do
Bailey.
you know whether or not...
Hold on.
Excuse me.
Be careful, Mr. Bailey. Proceed.
Did you ever learn if Mr. Simpson was ever asked any questions about a shovel?
Sustained. I'm going to sustain the court's own objection. That's hearsay.
All right. Did you ever ask Mr. Simpson any questions about a shovel?
I've never asked.
License was never asked anyone.
Overruled.
Did you?
I've never asked Mr. Simpson any questions.
Would you share with us, Detective Ferman, some of your educational background, high school, college, that sort of thing?
I went to Peninsula High School. I did not complete. I got a GED. I probably got
A GED is?
general education equivalency diploma.
Mm-hmm.
I attended 3 community colleges. I believe I currently hold approximately 47 units college,
What would that be in years?
close to 2 years.
And what did you study?
History, police science, art.
Okay. And have you had any other education beyond these community college experiences?
Are you saying formal education, sir, that I sought
Well,
out?
training courses, anything that would qualify as instruction.
Oh, yes, numerous
Okay.
numerous courses.
Did you serve for a time in the military?
Yes.
When?
1970 to 72, 73 to 75.
In what branch?
Marine Corps.
Reserve?
No, active duty.
Were you a regular?
Yes.
Or reserve status?
Regular, sir.
Okay. And what rank did you attain?
E5 sergeant.
And what, if any, educational courses did you take in the military?
Except for your basic MOS training, I don't believe I attended any courses.
Okay. And MOS means military occupational specialty?
Yes, sir.
What was yours?
Primary machine gunner, secondary military policeman,
Now, in connection with the military police specialty, some training is required before you can have that. Is that not true?
Well, not really. It's more of an on-the-job training type thing. You start out as a gate sentry, and then you work from there. If you have an aptitude, they'll
All right.
elevate you.
And what role as a military policeman did you play? Was it tantamount to being a patrolman or a gate sentry, or was it more like a detective?
Well, it started out as a gate sentry, and then I went to patrol. And at some point, I worked with CID on a couple things, but they were not.
CID stands for Criminal Investigation Division, the United States Marine Corps, does it not?
Yes.
Okay. And what kinds of cases did you work on with them?
Only one. I posed as a private, excuse me, waiting to get out of the service where they had a narcotics problem. And my role was just to play cards with them and see if I could elicit any information about a hashish connection that they were suspected of being involved in.
You were undercover at the time.
Well, somewhat.
Playing a role.
Yes, I was playing a role.
Okay. And was that your only nexus to any military investigations of suspected crimes while you were in the Marine Corps?
No, I investigated crimes as a patrolman.
Okay. Ever investigate any homicide?
No, I
Ever
did
attend any courses on investigation, how it should be accomplished?
not. No, sir.
Okay. When you were discharged from the Marine Corps, what did you next do?
I joined the Los Angeles Police Department.
All right. How did that come about? Can you tell us?
I applied for the police department, and I went to Los Angeles, I believe, 3 different occasions. Took the required tests, and I had an academy date approximately 2 weeks, maybe a little less, maybe a little more, to when I exited the Marine Corps.
I take it that you passed the test.
Yes, sir.
And how long after your application were you formally inducted into the police academy?
I don't recall exactly when I applied. I believe it was in 1975. But shortly after my EAS, or my end of my active service.
Now, I don't know that one. You're going to have to explain it.
End of active service.
That's EAS? Is it?
EAS.
Oh, okay.
Then I entered the academy on August 4th, 1975.
Then you had planned to become a police officer before you were actually discharged, is that correct?
Yes.
All right.
Yes.
How long does this academy last?
I believe it lasted 5 months at that time. I believe I graduated just before Christmas, 1975.
And what kinds of courses did you take there?
It was a long time ago, but your basic split up into 3 areas. You have shooting, physical fitness, and then academics. And academics, it went from everything to traffic citations, to tactical situations, to your investigatory responsibilities on crime scenes, to taking crime reports, English.
Now, you went to the academy with a view toward graduating and becoming a patrolman.
Yes, sir.
Is there a probationary period during which you can be discharged without any cause after you graduate?
Yes.
How long is that?
I believe it was 6 months then.
Okay. Tell me a little bit about what you learned on the tactical end of things at the academy.
Well, that was a long time ago. Officer safety was stressed quite.
Okay, well, let's talk about that. What are the principles of officer safety that stick in your mind from that experience?
Some latitude here,
I will
Mr.
tell you.
Bailey.
Do you remember any of the
The foremost,
particulars? The foremost.
the hands can kill you, the eyes can't.
Okay. And what about protecting your back?
Oh, absolutely.
When there is danger, normally officers go out in pairs to look after one another, do they not?
That's preferred.
And was that not a principle that you had learned, in fact, in the Marine Corps?
Yes.
Okay. Now, did you take any other courses, courtesy the LAPD or at its request, prior to the time that you became a detective?
Yes, sir.
Can you tell me just generally what kinds they were?
Yes, detective school, homicide. It was a combined detective and homicide school in that year. I believe it was.
So that was for the purpose of the upgrade?
No.
Okay. When did you first go to detective and homicide school? That's what I'm trying to learn.
The first time was 1983.
Okay. And did you complete a course?
Yes.
How long was it?
3 weeks.
And did you learn certain aspects of detection, particularly with reference to homicide cases?
Yes, in a general basis, yes.
All right. Did you have courses in firearms identification?
Are you talking ballistics or the forensics?
No, I'm talking about what most people incorrectly call ballistics, which is a bullet's trajectory. I'm talking about
Yes.
firearms identification, which means matching a weapon to a projectile. Did you have any courses in
No,
that?
excuse me, the class would be what your criminalist could do for you, not your
Okay.
involvement.
Right. Did you learn anything about fingerprints,
Yes,
footprints,
yes,
blood patterns and spatters,
yes,
protection of the crime scene,
yes,
preservation of evidence?
yes,
And did you also learn that delay after the discovery of a crime is generally the enemy of detection?
I don't recall that, no.
Don't recall that lesson.
No.
Well, did people tell you that, for instance, with respect to homicide victims, that bodies begin to deteriorate after they are dead?
Yes.
Changes take place,
Yes, sir.
all right? That insect and plant life may infect portions of the crime scene. Did you learn that?
Yes,
Okay. As I understood your direct testimony, you estimate that as a patrolman and detective combined, you've been at 150 to 250 homicide scenes, is that correct?
yes, sir.
And that as lead detective, once you became a detective, you have had 5 investigations where homicide was the crime,
Yes, sir.
and 10 more where you were with another detective. Is that what you meant to convey?
I think total would be to probably 5 more where I was accompanying as a secondary or,
So this would have been for you and Detective Phillips, had you maintained the lead, or for you at least, the 11th homicide case.
yes, as one of the
As a
detectives.
detective?
Yes, sir.
And was this the first double homicide?
Of this nature, yes.
Now, at what grade did you begin your detective work?
Rank, sir? D1 or Detective 1?
All right. Are there, in fact, 3 grades of detectives in the Los Angeles Police Department?
Yes, there is.
And you, at the time of this incident, had become a detective of the 2nd rank?
Yes, Detective 2.
And Detectives Phillips, Lang, and Van Adder were all of the 3rd rank at that time, were they not?
Yes, sir.
Okay. When you became a detective, did you have to take any additional courses in investigation, and particularly homicide investigation?
I did attend detective school once more and homicide school.
Well, what happened in '83? Were there no openings, or you didn't get promoted to detective at that time?
I hadn't taken the test, sir.
What's that?
I hadn't taken the test.
You took the course in '83 but didn't take the test?
Yes, that's correct.
I see. Why did you not take the test, if you remember?
Oh, well, you can answer the question.
No reason. I had a friend that said, "You want to go to detective school?" And I said, "Sure."
Okay. So you were kind of auditing rather than being enrolled? Is that your posture?
No, I was learning.
Okay. Did you go to precisely the same school or a somewhat different one when you formally took the detective's exam, or prior thereto?
Well, I think the school changed somewhat. They split homicide and detective school.
Mhm.
I first attended to detective school, which was 2 weeks, and then later I attended homicide school, which was 1 week.
All right. And what year was that, Detective Ferman?
I believe detective school was could have been 89. I'm thinking more like 1990, and I believe homicide school 1991.
Do you recall now the subjects that were taught to you in the 1991 homicide school?
Well, I don't remember them all now.
All right. Well, let's review what we can. Did anyone tell you at this time that you should be concerned about delays in the investigation of homicide cases?
I've never heard anybody phrase anything to do with the bodies at a scene in that way.
All right, well, you've heard it now. Are you saying this is the first time anyone's ever suggested to you that that's a principle?
Well, the way that that's phrased, yes.
Okay. You tell us then that in your judgment the lapse of time is irrelevant to the success of a homicide case?
No, not at all.
Well, Did you learn anything about what happens to bodies when you went in 1991?
Yes, sir.
Did you learn about temperature loss,
Yes.
postmortem lividity,
Yes.
rigor mortis,
Yes.
stomach contents and their possible deterioration,
Yes.
contamination by insect and plant material,
Yes, sir.
and the possibility that people at the scene, particularly if it's crowded, may contaminate the area?
Yes, sir.
Those are things that you were instructed to be careful about. Is that correct?
Yes.
Did you learn the manner in which time of death can, in some cases, be ascertained in homicide cases?
Yes, sir, several ways.
And what factors did you learn are relevant to establishing the parameters of a time of death?
I don't think I understand that exactly how
Okay.
you asked it, sir.
No doctor can ever say this victim died at 32 and a half minutes past the hour. It's not that precise, is it? No coroner can say that, can he?
I would agree with that.
Okay. So normally the time is bracketed by the coroner between 9 and 10, between 9 and 12, whatever, correct?
Yes.
All right. And is it generally true that the longer it takes to get to an autopsy, the broader the range of the coroner's opinion? If he knows.
Well,
I don't think I have the experience in this field to really answer. I think every scene would be unique to itself, so I don't know if I could answer that.
In how many homicide cases that you have been involved in as a detective, which I take it is now 11, has time of death been an important question?
I couldn't say, but I would say that not all of them.
Not all of them. Half?
I couldn't say, sir. I don't even have the homicides at the forefront of my memory right now.
You don't have any memory of the other 10 cases?
Well, I do, but right now I'm concentrating on this.
All right. Well, would you like a moment to reflect on whether or not you had ever had occasion in the past, prior to this case, to want to ascertain the time of death of the victims?
Yes, I could say yes.
All right. Do you have any recollection at all on how many different occasions that was a necessary part of your investigation?
If I could have a moment to
Sure.
think. I can think of one that was very important.
Okay. It is true, is it not, that the time of death can define the number of people who are potential suspects in a case?
I think it would be useful.
And it can also eliminate persons who might otherwise be suspects in a case, can it not?
I'm sure it could, yes.
Now, in this case, do you regard the time of death of the victims as an important factor?
I don't know enough about the crime scene on this case.
You don't? Okay. When you encountered Mr. Simpson and the woman you now know to be Nicole Brown Simpson in 1985, my understanding is that because you prefer basketball over football but still like football, you knew who he was as you walked up to him.
As I got close, I saw he was, yes.
Had you ever seen her before?
No.
Did you ever see her again up until the time of her death?
No, sir.
When you were at the scene, did you have any power to pat down anybody there? Would that have been appropriate police conduct?
Which scene is this, sir?
85, the Mercedes.
Oh. I believe I could have, yes.
Well, Mr. Simpson didn't have anything on him or in his hands resembling a weapon, did he?
No.
No. What would be the basis that you'd walk onto a person's land and pat them down? Do you have the legal right to do that?
At some point you do.
And did you have any legal right to arrest him on that day?
Oh, no, I didn't.
No. So that when Miss Clark asked you on direct examination, could you have arrested him? Your answer was what?
I don't believe it said I could have arrested him, no.
Thank you. In 1989, how did you learn that what you had observed in 1985 might be of interest to the city solicitor or prosecutor. How did you first learn about that?
The one and only time I learned, I was standing in front of the desk of Detective Sergeant Glenn Varner, who I was talking with early in the morning, having a cup of coffee.
Can you tell me about when this happened?
I'm sorry?
Can you relate this to the letter that you wrote to the city solicitor, which we've already seen?
Just prior to writing the letter?
Okay. Detective Varner said something to you?
No. No, he didn't, sir.
What happened?
Detective Mike Farrell came to Detective Sergeant Varner, who was his direct supervisor, and discussed the case, the '89 case involving Mr. and Mrs. Simpson.
Okay. And did you then volunteer the fact that you had encountered them 4 years prior to that?
No, not at that time.
But at some point, were you asked whether or not you could, if requested to do so, give some testimony about the 1985 incident?
No, I overheard Detective Farrell informing Detective Varner that the city attorney would like to have anybody that had been up there that didn't take a report to write a letter to the court.
All right. Now, you did not make a report in that case. As I understand your direct testimony, that's because you were driving the patrol vehicle and your partner was riding in the passenger seat, and reports were his responsibility. Is that right?
That's correct.
Okay. You mean to say that if you had been in the passenger seat, you would have reported something to the police department?
No, there was no report to be taken.
There wasn't any reason to make a report, was there, Detective?
No, sir. No, sir.
But in 1989, you found that the city attorney was interested in that incident, or any prior incidents between Mr. Simpson and Nicole, correct?
That's what I heard, yes.
Yeah. As a result of which, you wrote him a letter saying that because of the celebrity status of Mr. O.J. Simpson, the matter was indelibly pressed into your memory. True?
Yes, sir.
The kind of thing you won't forget for as long as you live. Fair statement?
Seeing Mr. Simpson, yes.
Yeah. Well, and the whole experience of being on his property.
Yes, sir.
Okay. And had the case gone to trial, instead of being resolved as it was, you were prepared to go and testify to essentially what you put in your letter. Is that correct?
I wasn't told that, and I didn't assume that, no.
Were you prepared to if somebody had asked you to?
Oh, I think I would have, obviously, I would have responded to a subpoena.
Now, in 1994, at 1:05 a.m., while you were sound asleep, my understanding is you received a phone call from Detective Phillips, correct?
Yes, sir.
Had you seen Mr. O.J. Simpson personally between 1985 and June of 1994?
No, sir.
Mr. Phillips told you that there was a double homicide in Brentwood and that one of the victims might well be the former wife of Mr. O.J. Simpson, did he not?
Yes, sir.
Did that bring to your mind your prior association with the Simpsons in 1985 as an investigating patrolman and as a potential witness in 1989? Did you remember those things?
I don't believe I even thought of that much at that time.
So I take it that the indelible press that was in your mind in 1989 had faded to a degree.
No, I don't believe that. I was going to a homicide scene. I was mostly thinking about how we were going to handle a double homicide scene and who was getting called in.
Hadn't Phillips explained to you that based on the information he had gotten, this was a special case because of one of the victims?
No, he never verbalized that.
Had you learned from him during that conversation that the commander wished to have Mr. Simpson personally notified as opposed to telephonic notification?
I believe I learned that when we were en route to the Rockingham address.
Okay. Now, following the receipt of this phone call from Detective Phillips, you arose, I take it, showered and cleaned up, etc., and drove in your car to the West Los Angeles police station. Right?
Yes, sir.
And how long does it take you at that hour of the morning where soon traffic is rather light to drive in from Redondo Beach?
It's fairly quick, probably 20 to 25
Can you see
minutes.
Council sidebar with that, Court Reporter, please?